The other court is proceeding as before, and the presentation remains as before.
The defense is posted as before. One addition. January, September. We adjourn to purposes of receiving the ruling, the bill application. The applicant, we are ready to receive it. You please.
So ruling So the applicant, through his team of lawyers, applied for bail on 3rd November 2025 when he appeared in court and produced 3 sureties who included the father, wife, and the area member of parliament, who is also a friend to the applicant. All their particulars were exhibited in court, that is the national IDs, their national IDs and their introductory letters from their area of residence. The state made a request to have time to verify the letters that had been presented, which request was granted, and the matter was adjourned today for the state to reply on the consideration of bail. Today, the state has made his response to the application for bail and largely objecting to the grant of bail to the applicant on numerous grounds, which I will point out here below in this ruling. However, the state had no objection to the suitability of the sureties that were presented by the applicant. On court evaluation of all the three sureties, they are considered to be responsible citizens of the high standing in the society, and in that respect, I will agree with the defense counsel and find all the three sureties substantial. So this takes me to the objection raised by the state attorney, which included the nature of the offense, the gravity of the offense, severity of the punishment upon conviction against the applicant, the accused being faced with other charges in Kawempe Chief Magistrate's Court, the likelihood of the applicant interfering with the witnesses, and the matter being of public importance, among other things. The state invited the court to deny the application, but in alternative, and in the likely event that the court declines to grant the accused person bail, invited the court to set stringent terms that would compel the accused person appear in court for trial. And he cited various authorities and provisions of the Constitution of the Republic of Uganda, particularly Article 23, 6A, Section 77 of the Magistrates Court Act, the Constitution, bail guidelines for courts of judicature, practice direction of 2021, with regulations thereunder, and they were all taken into consideration. In rejoinder, the defense team, led by Counsel Samuel Muizi Mulingwa, vehemently put a spirit fight against the state's response to the application, referring all objections raised as speculative and not backed by law, and went ahead to address one by one, which I will not reproduce here. However, considered in this to their full effect. And he also supplied authorities to buttress his argument, which I also considered. This court is alive to the fact that the accused person has a right to apply for bail, and is presumed, or which is premised on the presumption of innocence. And in reference 20, and that is in reference 20, Article 28 of the Republic of Uganda. And this court is also aware that the quest for bail is quest for personal liberty. I need also to note that as ably submitted by both the state and the council, the grounds for the grant of bail are clearly laid out in the Constitution, the Magistrates Court Act, and the bail guidelines, as I have seen. And among those grounds raised are the ones, among those grounds are the ones submitted by counsel for the parties, which I now proceed to address. As to the nature of the offense, the state submitted that the offense with which the accused is charged of is serious in nature, as it intended to cause harm to the person, to the security officers who are charged with the responsibility to keep peace, security, and order in the country. And according to him, this would be against the public interest and undermining the provisions of Section 77 of the Penal Code Act, which submission was refuted by the defense in the joinder for reasons that it is not, that submission is not supported by any evidence and therefore remains speculative. I wish to note that the charges against the accused person as submitted by the state, I beg your pardon, as it has a serious effect on the general public, which causes fear and panic amongst the members of the public. Therefore, such an offense is against the public interest. In the instant case, so as to where the accused has other offenses in other courts, I would agree with the defense team that each case is handled on its peculiar facts. And since the case is still ongoing, the case referred to is still ongoing, it cannot be used to impute character on the applicant. And as if the applicant has had a conviction on those matters, I believe the provision cited was misconstrued. As to the likelihood of the applicant interfering with witnesses, the state indicated to court that investigations in this matter are still ongoing, and that the applicant would interfere with the witnesses if released. And given the way the offense was committed, he would have access, according to the state, he would have access to the platforms which he used to commit the said offense. And that submission was refuted by the defense for reasons that no witness or materials were supplied to court, were shown to court to guarantee the interference, and invited court to disregard such an objection and grant the accused person bail. I wish to note that indeed, as highlighted by the state, the investigations are still ongoing. And given the status of the applicant in the society, being a deputy spokesperson of the lead opposition party in Uganda, with command and respect, and means, in my view, he would interfere with investigations, and there would be witnesses. So in order to preserve the integrity of the investigations and public confidence in justice, it would only be fair that the accused is temporarily remains in custody to pave the way for speedy investigations and for justice to be seen to be done. Therefore, considering the submissions of the defense team, the response by the state, the application, the rejoinder, and having considered the law, the nature of the offense with which the accused is charged of, its gravity, the status of the investigations, the effect of the offense on the society, and having considered the balance of interest between the applicant's right and the public, I decline to grant the accused person bail, but rather advise him to reapply when investigations are complete, and consequently direct that the state expedites investigations. I so order.
Your Honor, we seek an audience.
Yes.
Clarity on the timeline, on time limitation within which no one seems to get that. Because it can't be open-ended.
You seek for?
The timeline on the timelines, the investigations.
What does the law say?
Yeah, reasonable.
So in the meantime, the matter is adjourned to.
Your Worship, our worry is,
Yes.
since you've been categorically clear, but you can only grant bail after the closure of investigations. We want to. No, I'm speaking audience of course. Yes. Your Worship, our concern is.
Yes, I think let's observe the program.
Yes.
We speak one at a time. Yes. State. Can we hear from him?
Yes. Your Worship, from how we construe your advice, that actually you only entertain his bail application after that finished with
No.
investigation. So you wanted at least to advise, or if you may, encourage the state to expedite the
That's
investigation.
what I've done. That's what
Because
I've
they may
done.
investigate forever.
It
yet
can't
they
be.
manage
It's a
to
test of
find
reasonableness. You can't investigate forever.
most of them.
And at that, in that regard, the court will raise it at an appropriate time because it is an order. So we can have,
Your Honor, perhaps before, when can we access a typed copy of the
you will get it
ruling?
end of this week. End of, the week is ending tomorrow. In the course of next week, we can have it. So we can have second December.
It's available.
Yes? I'm hearing some.
Yes, something with the stage. Because we have the Tuesdays.
I have two state attorneys. One on Thursday, another one on Thursday and Tuesday, and he appears on Thursday. So since the matter is still at this stage, the other one, if he's not there, the other one will be there.
Let's take it. Let's separate.
So the accused is filed one until the end. And the matter is adjourned 2nd December 2025 at 9. For further mention, and the accused is remanded until then.
Freedom comes to those who fight, not to those who cry.